case number 110117 in the matter of Brendan Patrick Barker, the respondent. And before I ask counsel for argument, I did want to remind everybody that Justice Lukert, our colleague, is recused on this case, but she's being ably replaced by the distinguished-looking jurist to my right. This is the Honorable Martin Asher, who sits in Atchison as a district court judge, and that, of course, is the first judicial district. Judge Asher has read all the materials for this case. He'll be participating in the oral arguments this morning, as well as the case conference this afternoon and the ultimate resolution of this case. Judge Asher, on behalf of my colleagues, I want to thank you for helping out the Supreme Court today.
Thank you, Chief Justice. It's been my pleasure.
Very good. Counsel, with that, you may proceed.
Thank you, Your Honor. May it please the Court, I'm Alexander M. Walczak, Deputy Disciplinary Administrator. Chief Justice Nuss, with the Court's permission, I'd like to reserve 2 minutes for rebuttal.
2 minutes is granted.
There was a panel hearing involving the charges against the respondent on the 5th of June, 2013. At the panel hearing, the respondent filed an answer in which he stipulated to the factual allegations as well as to the 5 different rules of professional conduct. The panel proceeded to aggravation mitigation evidence, and following the proceedings, the panel rendered their final hearing report. On review before this court, the respondent filed exceptions and a brief. In the brief, the respondent asserted 7 issues. I combined them into 3 categories. The first was whether the finding by the panel that the respondent violated Kansas Rule of Professional Conduct 1.16D, the panel found that he did so by not refunding the retainer money which was unearned upon his abandonment of the client. In his answer, he stipulated he violated Rule 1.16A, which is that he should have withdrawn from the representation because his ability to represent the client was impaired because of his medical and physical condition. He also asserts as issue number 2, he challenges the element of knowing under ABA Standard 3, as well as 4 of the aggravating factors found in the 3rd issue is essentially that he argues that the recommendation for discipline, both from the disciplinary administrator and the hearing panel of the suspension, is inappropriate and that the correct discipline is a censure. I will address them in the following order. The Rule 1.16D, the panel was correct. The client, there's overwhelming evidence that the client paid the respondent a retainer fee of $1,825. The respondent did some work. The work was submitted to the Jackson County Probate Court. It was rejected as deficient. The representation was never completed. During after in some initial filings, the respondent abandoned the client for literally over a period of 4 or 5 years.
Mr. Walczak?
Yes, Your Honor.
Ordinarily, the way those things come down the pike is attorney sues for the fee, and then there's a counterclaim for malpractice or ineffective assistance kind of thing. But I see that as 2 different issues, whether he did the work to earn the fee versus whether he did it so poorly he should forfeit the fee. Is that a distinction without a difference? I mean, we're arguing here whether he earned the fee, whether he did the work to earn the fee. And I think the only way you get around that is to say he did it so poorly that he was not entitled to be compensated for the work that he did do.
Yes, Your Honor. I do see the distinction and the argument from the disciplinary administrator, and I believe as to what was found by the hearing panel was that the respondent did the work so poorly, so competently, that he did not earn the fee. It was unearned. And because of the rule 1.16D, which mandates upon the withdrawal, an attorney must refund unearned legal fees. So the issue here is unearned.
Can I also ask about, you suggested, and it partly goes to the pattern of misconduct question too. You said for nearly 4 or 5 years he mismanaged this case. Wasn't a new attorney hired after about 2.5 years?
What happened was that the client engaged the respondent in the fall of 2006, about October. There was some initial filings by the respondent during the period of November through November of 2007, all of which was rejected by the court. The probate court in Jackson County apparently reached the point where they were fed up, and they appointed the public administrator in February of, I think it was 2008, and then the public administrator brought suit against the respondent's client in 2009. At that point, the client retained an attorney to represent her in that lawsuit.
After a new attorney is hired, are you suggesting then that the respondent still owed his client an obligation, a legal obligation? That was my confusion. It seemed to me that you were lumping together the entire time from 2006 to the conclusion of the case, rather than the time of when a new attorney was hired. I know we're splitting hairs here, but I'm just curious what your position is.
And the issue here is that the respondent was the attorney for the record. He at no point did he ever withdraw. The Missouri rules, as pointed out in the brief, requires a formal withdrawal notification, written notification to client and the court. That was never done.
So even though new counsel was hired, took over the case, he still has some obligation.
He still has a professional obligation. And that is one of the arguments as to the mitigating, the aggravating circumstance, whether it's 2.5,
Right,
2 years.
I wanted to understand your position on that. Okay, thank you.
Is your position then that none of the fee was earned?
That is correct. You can't, I do not believe that the doctrine of quantum merit would apply, because here was an abandonment. It was not a withdrawal for good cause. And number two, most importantly, it was unearned. The second issue, I think, which is most important, is whether or not the respondent's conduct was knowing, or as the respondent would assert, it was negligent due to the fact of his misfortunes. There is no doubt that the respondent was well aware of the circumstances of the proceedings. He received notices from the Jackson County Probate Court. He asked for 5 or 6 continuances from the court of the show cause proceedings. He acknowledges receipt of some of the notices. The panel found that the conduct was knowingly done. He points out in his brief that he did not have the intent to do this. Well, under the definition of knowingly under the ABA Standard 3, intent is not an element. It's just conscious awareness. We covered patterns of misconduct. The next, he also challenges the panel's finding that the client was a vulnerable victim. He asserts that this court can only uphold aggravating circumstances on the basis of clear and convincing evidence, and that is not the evidentiary standard. As this court has said in the Walsh case, that the panels consider matters as to whether they're mitigating aggravating and go into a weighing evaluation. The client in this case was vulnerable. At the time she engaged the respondent, she was under quite a bit of emotional distress.
How do we distinguish anyone who retains an attorney in the capacity she was seeking his assistance in versus this particular person? Because all clients are vulnerable to a certain degree. That's why they hire lawyers.
Correct,
And so help me with why, in this case, she is particularly fits this versus anyone else who would retain an attorney for a conservatorship or probate matter.
My position would be is it depends on the facts and circumstances of any given case. As this court has said in the Wall case, it's more than just the client depending on or following the legal advice of an attorney. There has to be something in addition. And in the Wall case, the client in that case did not testify at the panel hearing. In this particular case, the client did testify in the panel hearing. The panel did have the observation to observe the witness as well as to hear her testimony, and she talked about her emotional distress, the fact that she did not know the law. Also, there was a number of significant events going on in her life at this time.
Does the respondent have to be? Is there any evidence that he was aware of this? Any of her emotional turmoil, the conflicts in her personal life?
I believe in my brief I made reference to his acknowledgement during his testimony that he was aware of that. Her father had died, the mother was ill, was in the hospital, then she died. He was aware of that.
Okay.
She started a new job. The job demanded that she travel a lot monthly, often outside the United States. The panel also found indifference to restitution. Again, the respondent asserts there's no clear and convincing evidence. That is not the standard. The respondent never made any attempt to make any restitution repayment to the client. The first time he did was at the panel hearing where he tendered a check for $5,000. What is important is that even if the respondent did not have money to pay the client, he could have worked out some type of, if he really cared, some type of a payment plan with the client prior to the hearing, and also as part of the recommendations of the hearing panel to this court, it recommended that the respondent would either make restitution or enter a payment plan. And as of yesterday, the respondent has not paid anything further towards restitution or entered into a payment plan.
Does the math work on there? I was a little confused between the, footnote 3 that talks about the check for $5,000, and it really just says it was offered. It doesn't say that it was accepted and cashed, and then the $21,000 amount is used in the end of the hearing panel's report. I think it's paragraph 56. As the full $21,000. So it seems like if the $5,000 was paid, wouldn't the amount be less?
Yes, that is correct. The math would be, I forget, like $16,000 subtraction.
Well, the $5,000 was tendered and accepted, and the check cleared.
Correct.
Sometimes we have those checks delivered during hearings and they don't clear. So
I've
that
been
part's been
advised,
paid.
Your
So
Honor,
our
it's
amount
cleared.
is $16,000.
Correct.
Okay.
I see, Your Honors, I'm out of time.
Would you like 30 seconds to summarize?
I'm asking that this court affirm the conclusions of law, the findings of fact of the hearing panel, as well as the recommended discipline from the hearing panel of suspension for 6 months, and before the respondent could be reinstated, that he appear before our Supreme Court Rule 219 hearing and demonstrate that he's capable mentally to practice law, and also that he has either made restitution or entered into a written payment plan back to the client.
Well, any further questions?
My understanding of part of the allegation is that he was trying to, or part of the mitigation allegations are he was trying to save some family businesses and was working on some Jimmy John's restaurants or whatever, which tells me that he chose to look after some personal affairs but ignore at the expense of some client affairs. What would happen at the reinstatement hearing to assure you or assure me that future clients wouldn't be subject to a choice of taking care of personal matters before the client's matters? You understand what I'm trying to ask you?
Yes, Your Honor. You're very clear. I don't believe at any point any respondent appearing before a reinstatement hearing can give a guarantee, if you wish, that future misconduct will not happen, that it happened before. I think this court would just have to
I understand that, but I guess my question is what do you show that will improve the chances that it won't happen again? What is it that, sometimes we have supervising attorneys, or we have other things that are proposed to ameliorate the chance that the focus will be not be on the client.
Well, I think in the respondent's case, two things. One would be is some type of assurances as to his mental state, whether that comes from a professional. And number two is what steps the respondent has put in place to ensure future misconduct does not occur. So it's almost like you have to hear from the respondent as to those steps. And then obviously this court would have the discretion or the authority to either reinstate or not reinstate.
Any further questions? Thank you, counsel.
Thank you, Your Honor.
While he's taking his seat, I might welcome our guest to the courtroom. Could you identify who you are, please?
Hello, this is a government class from Topeka High School, and we sit in to observe. We appreciate being here.
Good. Welcome. Thank you. Counsel, you may proceed.
Good morning. I'm Steve Pigg, appearing on behalf of respondent. I'll make a brief statement, and then Mr. Barker has a statement for the court. First, to address Justice Johnson's comments, Mr. Barker was a younger attorney who became overwhelmed by and overextended by matters that were unrelated to his practice of law. He now has resolved all of those issues and is focused on just the practice of law with no outside business interests that he's involved in. He also has completely restricted his practice to an office practice, estate planning. This matter involved a court appearance. He doesn't deal with court appearances. He had not dealt with court appearances very much at that time. And so he's made an election to avoid those kinds of problems by simply not practicing in that area and doing what he knows, which is to use his tax expertise, his LLM, and focus on estate planning for clients. Mr. Barker is here today not because he disputes the fact that he made errors. He's always acknowledged those. He's here today because the discipline recommended by the disciplinary panel of suspension is essentially a death knell to his practice. He was effectively suspended as a result of the circumstances for about 3 years during the time that this situation caused the problems for his client. For that to happen again will be a real problem for him. And a suspension has the counterproductive effect of limiting his ability to follow through with his commitment to reimburse the client for the monies that she's out. And at this point, I'd ask Mr. Barker to address.
A clarification on his estate planning occupation.
Yes.
What exactly, and maybe he can answer this, does he do? Some estate planners are not lawyers. Does it require, I know it's a dangerous question to ask, I suppose, but does it require a law degree to do what he's doing?
Yeah, I don't really know the answer to that
He
question.
can not that that's critical at all. I'm just curious when he says it's a death knell of his existence. I'm wondering if in some capacity can continue, at least in a way, of what he's doing.
And whether that's possible or not, there's a gray area, and he certainly wouldn't want to step into the gray
No,
area.
I wouldn't encourage that, but, yeah, okay.
Mr. Pigg, before you sit down, what's the rationale between the time that's passed from when the $5,000 was paid to today, when we don't either have a written plan to pay back or any additional money paid?
The absence of payment is a result of the inability to pay. He simply hasn't had the income yet to make those payments. He totally exhausted his available assets with a $5,000 payment. The absence of a written plan is simply, I didn't think that we should enter into, I didn't think about entering into one and recommend it to him. So he doesn't have a problem with entering a written plan. And our request is that he have a public censure. He remains committed to paying her and certainly would enter into an appropriate written arrangement.
I have another question that follows on that.
Yes, Justice Black.
Since when was the panel hearing exactly?
April of 2013.
Okay, so just a few months ago. Between that time and now, has he been practicing his estate planning practice?
He has.
Okay.
Now, he's somewhat limited in his ability to market himself and to expand his estate planning practice by the pendency of this proceeding, because he doesn't want to get out there and become committed and then be suspended and have to tell clients that he can't do it.
Mr. Pigg, you made the point that a suspension impairs Mr. Barker's ability to make restitution to this particular client, but is our job really to act as a collection agency for harmed clients? I mean, we have the Client Protection Fund versus protecting the public against someone that will do this. In other words, I view the real issue here, not whether he gets this client repaid, but whether he will do this to another client in the future. You understand what I'm asking you?
I understand what you're saying, and that is the purpose of suspension, is to protect the public. But there's no evidence here that there's been any other problems except with this client, and no indication that the clients that he has now are not totally satisfied. We've got letters from 3 attorneys, including Danielle Scavuzzo, with whom he's associated to provide his expertise in this area to help her clients, that established that he's doing a good job. Joe Price, who was the head of the Spencer Fain tax division, has co-taught with him at seminars, has reviewed some of his estate plans, and says that he agrees with what he has been doing. So all of the evidence is that this is an aberration. It was certainly unfortunate for him. It's unfortunate for his client. But there's no indication that this is a continuing or redundant problem.
Any further questions of counsel? Thank you, counsel. Your client would like to address us.
Excuse me. Sir, may it please the court. I'm Brendan Barker. I let a client down that had engaged me. I want to speak just for a second as to the $1,825 that she initially paid me was to initially form a guardianship conservatorship for her mother. That was done. That was done in an acceptable manner and in a timely manner. There was never any money taken from her. I've never taken money from a client ever where I have not performed work. I don't think that's good. I had a series, life started to steamroll.
Before you go on, I want to clarify, please. The $1,825 was to do the initial, what you're saying is to do the initial paperwork to establish the conservatorship and get her appointed?
Together with having a court hearing, which we did.
Well, I mean,
Yes, sir.
the process is you file it, you get the case number and you establish it, you get the letters of conservatorship. Of course, that doesn't really establish it. Then you have to file the inventory and you have to do the other things that are part of the setup. And I understood that that's where the disconnect came, is that you didn't get the inventory filed and you didn't carry that on through to get the conservatorship up and running rather than simply a case established. Am I wrong?
That's you're not wrong, but not entirely correct.
Okay.
Because this was, and Michelle Burge, who's a very competent attorney who I know, that stepped in here, even had problems finishing this case, and I even tried to assist her on it after the fact, because the mother died relatively soon after that conservatorship was established. And so what was being worked on was kind of a hybrid between an estate closure at the same time as winding up a brand newly formed guardianship conservatorship that was really never utilized. Does that help clarify a little bit?
Thank you.
And I did that. I know that practicing law is a privilege. And your job as an attorney is to give the client your highest and best. In this instance, I did not do that. I should have withdrawn. I don't have hindsight here at all. Neither does the client. Will I make the client whole? Absolutely. I've given her $5,000. That exhausted savings. I went through a complete collapse. I have zero assets. I have a car. That's all. I'm working right now. I'm limited in really what I can do because I can't really hold myself out and willingly take new clients and that kind of thing and try to ramp up a practice when I know that I might not be able to follow through with them. And that's limited it. I'm barely making ends meet. I get brought on by other firms as a consultant on some estate planning issues. I'm very good at what I do. I do not do guardianships, conservatorships. I should have never taken the case. I did. That's my mistake. That's why I'm here today. I don't do that. I don't have outside business ventures. Estate planning, wills, trusts, powers of attorney, helping somebody walk through the Medicaid process, things like that. That's what I do. Just normal, everyday people. And I'm good at that. There is a gray area between some estate planning things. I've seen 2 cases in the last month where the client never talked with an attorney, never anything, and there's not even anything anybody can do to help them because it's so far along in the process. Nobody's there. One partner, she's been a partner for 25 years, his kids are kicking her out on the street because there was no adequate representation. There's nothing I could do for her. And I hope that answers your question a little bit. Now, I'll answer any questions. I did make a mistake, and I've never once said I didn't. I never backed away from it, and I'm not going to. Will I pay her back? Yeah. I promise you I can pay her back a lot faster if I can keep building on what I've been working to achieve the last couple of years. But if I have to reinvent myself at 43 somewhere else, I don't even know what direction I'll take on that.
Let me ask you about paragraph 48 in the hearing panel report, which has to do with the finding about depression. Is this a current condition? Is this one that's being treated with medication or counseling? What are we talking about here? And I'm trying to tie this back to the need for the reinstatement hearing.
Sure.
Because that's what the disciplinary administrator is asking for. And frankly, if we suspend for 6 months, and then make you subject to a reinstatement hearing, the suspension will go on longer than 6 months.
I'm,
So I need to know
Sure.
what the medical and mental condition is so that we can figure out the need for that reinstatement hearing.
I'm fine. I went through completely lost everything. My entire family did. It wasn't just me that went bankrupt. Everybody went bankrupt. My brothers, who are both attorneys, my dad, who's a surgeon. I just lost my mother in May after a long bout of accelerated Alzheimer's that was brought on, the acceleration we think was brought on by that. So I was dealing with that. I was in a near fatal car accident where a drunk driver blocked an interstate and I hit him going 75. That took me out of commission for a year. I did get depressed. And when that happened, I couldn't pay my child support. I could barely pay anything. And I had 2 kids to provide for too. So I'm still making arrears payments on child support, but that got worked out. I was depressed at that time and I was not functioning at a high level at all. Today, my brain's clear and I function better than anything. And if all this has taught me nothing, it's that I'm a much more effective attorney. I'm much more effective for my clients. And I'm a more productive person because of what I've been through that. The unfortunate thing is a client who I did owe a duty to was harmed in the process, and that's something that I cannot take back.
Are you presently under any treatment or medication?
No. 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 That's all I have unless there's any other questions.
Were you at any time during this when you said you were depressed and couldn't function, or did you seek help at all?
There was a point in time I got diagnosed ADHD. I did that, trying to even think, kind of early on to help with focus. I'm a fidgety person. I'm an animated person. And I did start doing Zoloft and Adderall, that kind of thing. You know, when you go to a psychiatrist, that kind of...
How long ago was that?
I have not taken anything in...
I mean, was that during this period of time you were talking about?
Yeah.
Okay.
Yeah. I was doing that. I haven't taken anything in probably 5 years.
Okay.
Do you have any further questions? Thank you, counsel.
Thank you for your time.
Reserve 2 minutes for rebuttal.
Members of the court, I waive rebuttal. I will answer any questions if there are questions, though.
I need you to talk about the reinstatement hearing and what you see as the need for that, because you earlier had talked about it being necessary to ensure that the respondent was able to re-enter the practice, but usually when we have that, we've got some condition or issue that we're really focused on, at least the representation from the other side is that that isn't an issue. So I need to know whether we're just looking at suspension for the purpose of discipline, or are we looking at the need for a reinstatement hearing as well from a protection of the public standpoint?
I'll try to answer that. Your Honor, at the panel hearing, the respondent testified, and it's also portrayed in his brief, that during the period of time of the representation 2006 to 2011 time period, he was under deep depression, and for the events that he testified today about. The panel asked a series of questions of whether or not he received any treatment for the depression, and his answer was no. I believe the panel had significant concerns about the respondent's mental state and whether or not, as assurances to whether or not future misconduct would occur. And so to satisfy those assurances, they wanted the respondent to demonstrate at a 219 hearing that he was mentally fit to practice law. Second, I think there is the issue of whether or not there was really an avowed effort by the respondent to either make restitution or commit to a restitution plan. And so the reinstatement hearing would provide that vehicle, if you wish, or leverage to ensure that that would happen.
Any further questions? I just wanted to make clear, perhaps you can answer this, or the respondent or his counsel, what is the respondent's position in terms of discipline in this matter?
The respondent, at the panel hearing and in his brief, asked for censure and the censure be published.
And that is still your position today?
That is our position, and in addition, we would agree to some type of payment plan or some written commitment or an order of restitution.
Very well, thank you. Any more questions? I see none. Thank you. Thank you all for your arguments this morning. The court will take this matter under advisement. That concludes this morning's